The issue today is whether the ex parte order that Judge Fowler issued on January 14 would remain in effect if this case moves forward in the ordinary course. I've read that order, I assume you have as well, that indicated to the effect that considering the facts contained in the verified petition and the offer made by counsel, I assume that was you, Attorney. That's right. The court finds a temporary injunction is necessary to avoid irreparable harm should minutes and other records subject to RSA 91A, the right to know law, be destroyed or otherwise disposed of. Accordingly, until further order of the court, the County of Carroll shall not destroy, remove, or otherwise dispose of any county commissioners' meeting minutes or any other records which may reasonably be construed as subject to RSA 91A with a hearing according to court rules scheduled for 10 days. So, Attorney Bailey, let me start with you, if I may. Does the county object to having this temporary ex parte order remain in effect until the matter can be heard on its merits?
No, Your Honor, although the county will likely dispute some of the facts alleged in the petition in due course, the county does not object to the order remaining in place, and it is my understanding that all three of the commissioners likewise do not object to abiding by the order.
And since they're separately named in both their official and individual capacities, I mean, you know disrespect, but I'm going to have to ask each of them, since they're appearing separately and individually today, whether they agree to keeping that order in effect until we can move this forward.
Is there a megaphone? Can you do that, please?
Good morning to all three of you. The issue today is a limited issue, and that is whether Judge Fowler's order, basically maintaining the status quo, nothing that may be subject to the right to know law, to be destroyed, removed, or otherwise disposed of until we can get this sorted out on a merits hearing. That's what we're talking about today, and only that, although we may talk about scheduling once that's resolved. The question is whether any of you appearing in your individual capacity have any objection to that. If you could state your name and then tell me whether you object to that or not.
Dave Sorensen, and I do not object to it.
Dave Babson, Your Honor, and I do not object to it.
Asha Kenny, and I do not object to it.
Thank you. So all, first of all defendants have appeared, all have indicated that they do not object to maintaining the ex parte order that Judge Fowler issued in effect until this can be resolved on its merits. Unless you have something else to say on that topic, my intent is to convert Judge Fowler's order to a preliminary order to remain in effect until it gets resolved on the merits. That is consistent, I must say. He didn't cite there are several cases, Aetna Casualty is the case I usually use, talking about maintaining the status quo, just keeping things as they are until merits issues can be resolved. That's what we're talking about here. Attorney Hipple, anything further on that topic?
If you would like, Your Honor, I can give you a brief synopsis of why we asked for the order.
No need. I've been through both the original petition and your particular ex parte request. I was not here as Judge Fowler was, but just from the petition and the ex parte request, I understand where the order that Judge Fowler issued came from. And it is my intent to convert it to preliminary.
I can represent the court very briefly that at the January 15th meeting, Commissioner Sorensen did confirm, for all intents and purposes, that the matter of destruction of records was discussed in non-public session. And I actually have a motion that I want to submit to the court, if I could approach.
Okay.
I do have copies for defendants.
Appreciate it. I'll mark it as filed in the courtroom today.
And if I could just be briefly heard on it, Your Honor.
Actually, I don't think there's anything to be gained from being heard on a motion that the parties have 10 days to respond to. They may agree to it, they may object, they may agree in part, object in part.
Okay.
So
Then I'll just explain what it is, Your Honor. Basically, what I'm asking for is that the non-public minutes from January 8th be ordered to be released for two reasons. One is that the non-public minutes were not, there was no recorded vote within 72 hours of January seal the minutes. And second of all, the statute makes it very clear, and the commissioners with their 15 years of combined experience are well aware that when you go into non-public, the non-public session is confined to the issue on which the motion is premised, which was personnel. They know as well as anybody else that destroying county records is not personnel. They broke the law. They can't be allowed to law breaking by keeping these minutes shielded from the public.
And since Attorney Bailey, since I allowed Attorney Hipple to make a brief statement, notwithstanding that the motion isn't right, if there's anything you'd like to say, I'll permit you to do so.
Thank you, Your Honor. Certainly, perhaps a phone call would have been in order to try to figure out this could be worked out rather than motion practice. But unequivocally, the county commissioners and the county did not break the law in terms of the discussion of the non-public session based on information relayed to me. So
After you've had a chance to read the motion,
I
I
have.
take it that you'll use your opportunity to respond?
I will do so, and I think it's particularly important that there is an opportunity to respond in light of the fact that the three commissioners are currently about to appear pro se.
Well, the rules provide 10 days
Right.
to respond, assuming that there's no request to extend that time. So nothing will happen within 10 days. So, you each individually have a right to respond to any motion that's filed, along with the county as represented by Attorney Bailey. Those are individual decisions you'll make on your own, or if you're represented by an attorney, with your attorney. But the clock on the 10-day response time does start today, because it is filed here in the courtroom today. Is there a procedural question, sir?
Yes, sir. Is that verbally or in writing?
The response.
Responding, is it verbal or in writing?
Good point. It has to be a written pleading in the proper format. That is not a letter addressed to the judge, but instead in a motion form. No particular formality other than that is required, other than the fact that anything that you file with the court goes to Attorney Hipple and to your co-defendants, whether represented by counsel or not. Thank you for raising that, sir. And it has to be filed within 10 days from today. If that falls on a Saturday, Sunday, or holiday, it extends to the next business day beyond. All right. If you all don't mind, this may be a little unfair to you folks if you're going to be represented by an attorney, but I'd like to get a sense of what we're looking at for the final hearing. In this case, what kind of time frame, how quickly you're thinking it might occur. I'll start with you, Attorney Hill.
Your Honor, I would ask for a full day. That may seem excessive, but if you've read the petition, you have, the issues are rather complicated. It takes time to go through these records, especially since they're so incomplete. And we expect to call between 4 and 5 witnesses. So we would ask for a full day. We're prepared to go as soon as the defendants are ready.
And as I say, probably unfair to you as well, Attorney Bailey. I'm just trying to get some sense from the clerk about what kind of pace this case is likely to be on and how long it's going to be required.
Certainly, I don't have a feel for how long any final hearing would go. It does seem to me we have 30 days to file an answer from the date of service, which is, I think, about February 14th. One of the questions I have just initially is whether some or most all of these issues can be resolved in advance of the final hearing through communications with counsel. So I'm sorry I can't be more exact in estimating how long a hearing would take on this. I don't know at this point.
That's fine.
Thank you.
Any of the three of you wish to be heard on pacing or how long you think the final hearing might be once we get there? I'm not requiring you to say anything. From Attorney Hipple, I have what I needed. Attorney Hipple is estimating a day, and so I'll communicate that to the clerk, and she can begin to look ahead, consistent with the kind of pace that right-to-know actions usually move at. And so to be clear, it may be that we end up using less than a day, but I'll be asking her to find a full day. So there's plenty of time to resolve it once we get to the merits hearing. Is there anything else we can accomplish today? I'll be issuing an order. I'll do it before I leave tonight, converting Judge Fowler's temporary order into a preliminary order to maintain the status quo until we get to the merits. Attorney Hipple, anything further we can accomplish?
No, Your Honor.
No, Your Honor, thank you very much.
Commissioners, any questions? Anything else that you'd like to raise today?
No, Your Honor.
Oh, thank you.
All right. Thank you all very much.
Thank you.
I'll get that order in the clerk's hands before I leave tonight.